Hey friends, Caroline here. Roe versus Wade, Brown versus Board of Education, Marbury versus Madison. The outcomes of these landmark cases were determined by the highest court in America, and they came to shape America's legal, cultural, and political landscapes for generations. But what exactly is this Supreme Court? How does it work? And why do the outcomes of the cases that reach its stone steps have such a lasting impact on America? At the end of the lesson, you will be able to analyze the Supreme Court in terms of its process, the power of judicial review, and the ways in which it is checked and balanced. Throughout this series, we have covered so many different aspects of the judicial branch of our government. Today, we head to the top, the highest court in the land, the Supreme Court. No, the Supreme Court does not examine parking ticket violations or even high-level felonies. They do not determine someone's guilt at all, actually. So what exactly does the Supreme Court do? Let's take a look at just how the process to hear a case works. So, how does a case make it to the Supreme Court? Good question. Now, the court only hears cases brought to it. A case must come to the Supreme Court. Petitioners must file what is called a writ of certiorari that includes arguments on why the case should be heard. Cases taken usually involve issues of national importance, or clarify, adjust, or reverse a previous precedent, or that the case tests the constitutionality of a specific government action or law. This petition is called a writ of certiorari. Finally, 4 out of the 9 justices must vote yes to accept the case. Phew, that's a lot of work there. But it reveals how important a case must be to reach the highest court in the land. Makes sense, right? Now, if a case is accepted, it goes into the docket, and each side of the case issues a written brief for the justices to review before the parties start giving their oral arguments. These briefs, as they are called officially, explain each side's position and cannot be more than 50 pages. You could write 50 pages, right? Ugh, I knew you could. The oral arguments last from October to April. These are open to the public, and the court hears 2 cases per day. Each side has 30 minutes to present their case. The party who filled out the petition goes first and can leave time for a response to the defense. After the oral arguments, the justices go into conference. Only the justices are allowed in these conferences. In conference, the justices get together to decide which cases to accept, as well as to vote on cases from the week, which result in a holding or decision about how the law should be applied. As far as reaching a holding on a case, generally the justices want to have a holding on a case by summer recess. The holding that the court lands on always has precedential value. The final opinion is made up of the majority opinion, any dissenting opinions, and concurring opinions. Only the majority opinion creates the holding and thus impacts the law. The majority opinion details the ruling and includes the justice's rationale and the constitutional impact of the precedents that is set by this opinion. If the vote is not unanimous, there will be dissenting opinions. These dissenting opinions disagree with the majority opinions and state the opposing views. Lastly are the concurring opinions, or those who agree with the majority but have a different interpretation of the law in question or some other aspect of the case. Concurrent opinions often provide the basis for future arguments about the issue. Before we move any further, it's time for a Show What You Know! Please grab a notebook and a pen or a pencil. We just went over the steps for how a case is heard and ruled on by the Supreme Court. List the steps in order. Let's talk about the idea of judicial review. What is judicial review exactly? Well, for one, it is the most important role of the Supreme Court. The process of judicial review involves defining constitutional clauses and also gives insight into their application. Judicial review establishes that big, important word we keep saying again and again: precedents. Precedents provides the lower courts a standard by which to decide cases. But how did precedents come to be? Well, in Marbury versus Madison, the power of judicial review, or the power to establish precedents, was established. In the majority opinion, Chief Justice John Marshall declared a provision of the Judiciary Act in 1787 unconstitutional, and by doing so, he established the court's power of judicial review. You go, Justice Marshall. Now, as we said, the process of judicial review creates precedents, and that precedence influences and often gives the instructions for how to apply the law. Judicial review can negate or void a law. It can change policy by stopping an executive action, like federal mandates, and it determines future laws and actions because it has defined what the Constitution actually means. That's a tremendous amount of power. With great power also comes great criticism, especially in a country like ours, which likes to have our checks and balances. Those who have criticized the power of the Supreme Court argue that the court destroys the system of checks and balances, as well as the separation of powers, for a few reasons. First, the Supreme Court is unelected and therefore should not have the power to affect the laws. Second, critics argue that the Supreme Court should have a more limited scope in their rulings and that it should not accept cases with large precedential effect. And third, these same critics argue that the Supreme Court should instead ensure that their rulings remain within the initial interpretation of the law in question, rather than make large constitutional statements, arguing that these large statements are in fact unconstitutional. Time for you to show what you know. What is judicial review? How does it influence the nation? What are the arguments against the power of judicial review? Now, that doesn't mean checks and balances don't exist for this highest of courts. The only way for a ruling from the Supreme Court to be changed is by Congress changing the law, or, with the states, Congress changing the Constitution itself. And while a president cannot overturn a ruling, the president can choose to not enforce a ruling. Sounds crazy, right? Let's look at an example. Worcester versus Georgia, the same issues that occurred in a case called Cherokee versus Georgia, issues which centered around enforcement, were finally taken up by the court. In this case, the court ruled that only Congress could regulate relations with Native American tribes. In response to this, President Jackson famously said, "The courts have made their rulings, let's see them enforce it." And Jackson was right. The ruling went unenforced, showing that the president does have a way of checking the Supreme Court's power. Stop the presses! Jackson did what? No, but seriously, show what you know. How do the other branches check and balance the Supreme Court? Recap! The Supreme Court only hears cases it chooses to hear, and each side has a limited time to argue its perspective. Supreme Court has the power of judicial review, which creates precedents. Critics argue that judicial review disrupts the system of checks and balances and therefore is unconstitutional. The Supreme Court is checked and balanced by the fact it cannot enforce its rulings. So if you ever make it to the bench as a Supreme Court justice, you, my friend, have one of the most powerful positions in the land. And with that, we say goodbye. As always, don't forget to vote, debate, and participate. Hey, hey.